Good morning, good afternoon, good evening, everybody, depending on where you're watching from. Welcome to another Smokin Bulls podcast, the podcast about business, money, and lifestyle. I'm Tyler.
I'm Dave.
And today we're joined by Greg Bentz, lawyer at Stillman LLP here in Edmonton. We're going to be talking to Greg today a bit about the benefits of being incorporated. Before we jump into that, I got a little bit of housekeeping items to attend to before we jump into our conversation with Greg. Today's going to be a presentation of about 35 to 40 minutes with Greg. We're going to open it up for questions at the end. So if you've ever used Zoom before, you'll know that down at the bottom, there's a place where you can post your questions. We'll moderate those from this side and post your questions to Greg. He'll do his best to answer them. If there's anything that's overly confusing or requires a long conversation, we'll certainly put you guys in touch after the meeting today. So I think that's everything we need to touch on today. So let's jump into our conversation with Greg. And before we get into hearing his formal presentation, I'll just introduce Greg a bit, and hopefully I don't butcher this too badly. But he is a partner over at Stillman LLP. He began his career there as a summer student and has continued to grow and develop his legal career since then. Greg works in a number of areas of practice, and a few of areas that he likes to focus on is business law, civil litigation, construction law, employment law, estate litigation, personal injury, real estate law, and wills and estates. So, Greg, we're going to turn it over to you to share with us your thoughts around corporations here in Alberta and in Canada and the benefits of having them, why you would have them. So thanks very much for being here.
Well, thanks, Tyler. Appreciate it. Thanks, Dave and Tyler, for having me.
Yeah, you bet.
I do appreciate the time. The airtime to air some of my grievances.
You can take a break from chasing ambulances. And so that's
well off the start. Yeah.
Okay, so wanted to talk about protecting your assets and about, in particular, business assets, because there is kind of a systematic way for people to build up their nest egg for retirement. And so if you are an employee, for example, and you work your life and you pay into a pension, or if you pay into RSPs, you build up a little nest egg that at the end of the day, you get to wind it down and retire. And the same can be true if you're a business owner, but there's a lot more pitfalls. And so that's why we're going to talk about the benefits of incorporation for business owners. As a business owner, there's a lot more risks out there. So you are always in the crosshairs of litigation when you do business, whether it be you send an invoice to somebody and say, I want it to be paid. There's a risk that can lead to litigation. You're dealing with the world at large, and the world at large can be a litigious place. And with litigation comes costs, comes liabilities. You may think that you've done nothing wrong, but in fact, a court may say you have done something wrong and therefore make you pay another party a whole bunch of money. So with that, there's kind of twofold. One, an employee very seldom gets sued for what they do. So they're not really in the crosshairs of litigation. But if they do get sued, also the employer will generally get sued in the course of a business. So if a business gets sued, very seldom does an employee get sued. And so you have this kind of double whammy on business owners that not only if they make a mistake, their employees can make a mistake and they're in the crosshairs of litigation. So how do we deal with that, and how do you manage your assets so that you can, at the end of the day, sit back and retire and enjoy your golden age? So if we can maybe flip to the next screen, there would be kind of a few things that we would talk about. I'm not sure what you guys are looking at, but there we go. Yeah. And if you can flip to the next one, just a brief little agenda as to what we'll talk about today. And that is that we're going to talk about what kind of businesses you can do. So a business can be dealt with in many different ways, and how you protect those from creditors is kind of what I view it as. And then we'll talk a little bit about, after you've incorporated, how we deal with that.
Perfect.
Yep.
We'll just work on getting your slides up here, Greg.
Yeah, sure.
Well, we'll just roll along.
Yeah, you can go ahead and
Yep.
keep your conversation going. And
Yeah, okay.
we'll bring them up.
So the first type of business venture is the classic one, the most ancient, I suppose, is the sole proprietor. So Tyler says, I want to build some widgets. And Tyler says, I'm good at building widgets and people like to pay me money for my widgets. And a widget is just kind of a placeholder for whatever it is that you want to do. As a sole proprietor, you are personally the person responsible. Your name and the business name are one and the same. So that's what a sole proprietor. So if we can then flip over our slide to the next one, the next type of business vehicle would be a partnership. So Tyler, Dave, and Greg say, hey, Tyler, you're good at making widgets. I'm good at installing widgets, and Dave is good at selling widgets. Why don't we partner up and we can go out there and make a whole bunch of money together? So that's what a partnership is. The problem with a partnership is that each partner is liable for the other partner. So not only am I personally responsible for what the business does that I do, but if Tyler messes up or Dave messes up, or there's a perception that they mess up and someone sues us, all three of us are jointly on the hook. So there's ways to minimize that. There's things like limited partnerships and LLPs as well, but ultimately we'll touch on that on another episode. So if we can flip the screen, one way to protect ourselves from each other is we call it a joint venture as opposed to a partnership. And so that there's a way that you can kind of segregate Tyler's end of the business from mine. And there's ways that we can make sure that if you get into trouble, it doesn't drag me into it. So that's another way to do business. And then if we can flip the slide, the next one would be incorporation. And so that's kind of the classic one. And that's what a lot of people will know about and have heard about. And a corporation, when you set up a corporation, you create a separate legal person. So it's a separate person altogether. So if Tyler, Greg, and Dave decide that we're going to go into business making widgets and we're going to incorporate, well, the three of us aren't that business anymore. It's the company that owns that business. We own the company as a shareholder. We tell the corporation what to do if we're directors, and we can be employees of the corporation. We can be the president. We can be the secretary. We can be the treasurer. We can be the guy building the actual widgets. We can do all that stuff.
And we all die. The corporation lives on.
The corporation lives on because it's a separate legal person. So if something happens to one of us, the business carries on. If something happens to all of us, the business carries on. And that's a good point. So those are kind of the main way to deal with it. But then let's talk and look at this and say, how do we protect the assets? So in a sole proprietorship, so that's where Tyler says, I'm going to make these widgets. How does he protect and build up that nest egg for retirement? Because if he does something wrong in the business, all of his assets are up for grabs. And by that, I mean, creditors can take your house away. They can take your bank accounts away. If you have a nice savings portfolio, they can take that away. So again, in a business, it might be an employee that messes up and now your house is on the hook, right? An employee messes up or somebody sues you who's just extremely litigious for no real good reason. Your house is up for grabs. So in a sole proprietorship, it's a lot harder to protect your assets. There are ways to do it. You can have insurance, put insurance in place, but in the context of today's point of view, insurance is probably not enough. And so we want to look for other ways to do that.
I'm going to jump in just with a quick question. If you're a sole proprietor and something happens to you in your house, say, for example, is on the line, what happens if that house is joint with a spouse? How does that work?
Yeah. So
just half the house is on the line or?
Well, it depends. That's kind of one of those questions that we'd have to look at on a case-by-case situation. But so that would be another way to protect yourself. You could say, oh, I trust my wife, so I'll put it in her name alone. Then the house would be for sure protected. Whether it's jointly or not, sometimes that gets a little bit complicated. So insurance, changing assets into someone else's name, like a wife or a spouse, that would be another way. So moving on to the other ways to protect yourself in a partnership. So if we can change the slide. Yep, perfect. The partnership is actually even worse because in a partnership, in a true common law partnership, which is the idea of two or more people trying to make money together, that creates a partnership. So now not only is my house up for grabs if I've done something wrong, but if Dave or one of Dave's employees, because we're partners, if they do something wrong, I'm on the hook for that. So that gets harder to protect yourself.
Is a partnership a legal entity, or is it just a?
Partnership is created under the Partnership Act.
Okay.
And it is I'm not sure if it's a legal entity or not. You can sue a partnership, but whether or not they, like for tax reasons, sometimes they're not considered. You'd have to talk to an accountant about that kind of stuff. But a partnership is something that can be sued. And when a partnership is sued, all of the partners are, by virtue of that lawsuit, named in the lawsuit.
Okay.
So there's ways you can limit that. You can create a limited partnership, which puts all the blame and all the responsibility on one of the partners, but that would be a topic for a different day. And then there'd be joint ventures where you'd say, okay, well, let's agree that we're not partners and that what's Dave's is Dave's and what's Greg is Greg and what's Tyler's is Tyler's. So in the example of the widgets, Tyler's manufacturing these widgets. Well, that has nothing to do with me installing those widgets.
Right.
So we have an agreement that if I install it improperly, and someone sues me and they name Tyler, that I would have to indemnify Tyler. So it doesn't stop him from being in the lawsuit, but at least you'd have some kind of protection.
Yeah. A lot of that in the construction business.
Yeah, exactly. Yeah. So then how do we protect ourselves in a corporation? If we just to the next one. Yeah. So this is the basic corporate structure. So you have shareholders owning a corporation, and the corporation does the business. And so as a result, the corporation exposes itself to the world at large. So in the widget company, you got two shareholders. You got Tyler and Dave are the shareholders in Widget Company Ltd. Or incorporated or limited or corporation or corp. It'd have to have a name like that once you incorporate. But now what you have is an entity that can be sued by the world at large, and you have shareholders that are relatively protected. Meaning if somebody sues the business, generally speaking, that means they have to sue the corporation and they can't sue the shareholders. Never say never, of course, but generally speaking, that's kind of the rule of thumb. So they would sue the corporation. The shareholders would still be drawing their earnings via employment wages or by dividends. Either way, that money isn't exposed to the world at large. Again, generally, because there are certain circumstances where it can be.
Okay.
So now this widget company of ours, our business, we're starting to really take off. And we go, you know what? Instead of renting the equipment to build these widgets, why don't we buy the equipment? We're making so much money that our accountant is telling us not to draw any out personally. Let's keep it in the corporation. So we're doing well here. We're okay. This is good. We get to take advantage of some tax laws and keep the amount of tax that we're paying to a minimum or as low as possible. And so to do that, we got to leave the money, leave the assets in the corporation. So what happens now? And so I'm going to go back to this kind of initial on the slideshow, this diagram where you have the corporation. This is fine. The corporation owned by the two shareholders. If the world at large sees an opportunity to sue the corporation, and for whatever reason, the corporation can decide, that's fine. We don't want a part of this lawsuit. We can't afford to even be in this lawsuit. They can shut down that corporation, and that corporation, being a separate legal entity, is done, and that's fine. It's an analogy I like to use is a lizard and a tail. So I don't know if this is biologically true or not, but from what I've heard is there's certain lizards anyways, that if a predator gets it by the tail, the lizard can scurry off and all the predator is left with is the tail. So it would be a similar analogy in the corporate structure. If there's a predator out there and they're suing you and they're making your life just, you can't do business anymore, you can shut the corporation down. You could hand over the keys to the corporation to that creditor and say, there you go, you got it. You know, the corporation consists of a pad of paper, an old fax machine, and an old laptop or whatever it is. And so that you give that to the creditor and the shareholders should be left unscathed. The shareholders would then be open to open up a new corporation and do business under that new corporation without penalty. And there's some caveats to that, and I'll talk to you a little bit about that in the next kind of corporate structure that we look at.
It's interesting. I've always find doing business with certain companies, you know, if they got a a year beside their corporation name, I'm like, AAA roofing, 1999, AAA roofing 2000. It's like
exactly.
You're just prepared to fold your corp. I see a year beside a corporation name. It makes me a bit nervous.
Yeah, especially if it's a recent year.
Yeah, personally.
Yeah. So there's reasons why that may happen. One of which may be that it was sold, and so they wanted to identify that it was a new entity.
I see.
But you're right. Yeah, and of course, banks and financial institutions know this. So when they deal with a corporation, they don't just say, "Okay, sign a contract with us. You promise to pay us back the money. Good, that's good enough."
Yeah.
They'll get personal guarantees involved and make sure security is tied up. So, but in respect to just kind of a general creditor from litigation, you have this lizard analogy where the creditor grabs the tail. The lizard is free to live another day. It's not pain-free escape. There is going to be some hurdles for those shareholders, but at least they can build towards that nest egg, that retirement nest egg.
Right.
So now we get back to the widget company that you guys are doing so well at, and you're keeping assets in the corporation. Well, that defeats the whole lizard tail analogy, right? Because now if they grab that lizard by the tail, we can't afford to give it up. We just bought all this equipment. We own all this stuff. We can't let them take it over. So we're going to be embroiled in this litigation, which we think is baloney. But now we're, $500,000 into a lawsuit, and we have to sell those assets anyways to pay for the litigation of it all. So what do? And if you click the next slide, we do this. And what this is a series of things that make accountants happy and lawyers happy and business owners unhappy, because it costs a lot of money and it is very complicated, or it can be kind of complicated. But what it does is it protects you in that event. So here you see that the shareholders own Holdco, and Holdco owns OpCo. Okay, so those are kind of names that we use to say, okay, well, Holding Co would represent a company in our widget example. We might say, well, Widget Holding Company will own all the equipment, and it will then lease that equipment to Widget Operating Company, and Widget Operating Company will deal with the world at large. So Widget Holding Company doesn't deal with the world at large. It deals with only one entity, and that is the operating company. So there's very little exposure there. So as the money goes into OpCo or to Widget OpCo, it then has to pay rent, it has to pay salaries, it has to pay all these expenses that the shareholders get the benefit of. And anything left over goes into Holdco, where you can build up your nest egg. Okay, relatively free from harm. So again, I'm going to go back to that idea of, well, why can't you do that anyways? So if you have just one corporation and you build up this nest egg, somebody sues you, that you're in the crosshairs of litigation and somebody sues you, why not just take all the assets out of Holdco, give it to the shareholders, and be done with it, right? That seems like a pretty easy move, and it would be, except for that would be what they call a fraudulent preference, and you're not allowed to do that. So one of the reasons a shareholder can get sued is if it receives something from the corporation that the corporation can't afford to give it. So in the face of creditors, you can't just say, okay, I'll take all the assets and give it to the shareholders. That would be a fraudulent preference, and it could be unwound. The shareholders would be named in the lawsuit, and the whole plan would be for nothing. So well before the corporation has any assets, you'd want to set up this Holdco OpCo structure. And OpCo, of course, now is exposed to the world. Holdco is relatively protected. And then you'll note on this version here, we have LeaseCo. And LeaseCo is kind of a placeholder name for LeaseCo or LandCo. So our widget company, we're doing super well. We're going to buy a building. We're going to operate out of this building. Well, owning land, having a lease, is exposure to the world at large. Now all of a sudden there's some more exposure. So, owning land, Tyler's busy making his widgets and he burns down the building burns down the neighborhood. The neighborhood at large will come to the owner of the land and say, how did you let that happen? Maybe there's some liability in owning the land. And so what Holdco does, Widget Holding Company, says, we're going to incorporate Widget Land Company, and it will own the land. And so if there's any liability associated with the land and ownership of the land, it's limited strictly to that holdco. And then, of course, it would funnel money back to its shareholder, being the holdco, where it sits, and you can invest it or dividend out to Tyler, Dave, and Greg. So that's kind of the idea there. And then this is one version. And I think if you click the slide, you're gonna see you can set up corporation number 2 and even corporation number 3. And this is where accountants will get involved and say, oh, well, maybe the shareholder should own the ultimate shareholder, Dave, should own shares in OpCo 2. And there's a way that there's capital gains, benefits, and that kind of jazz that I won't get into. But you can get this web very complicated and very fun. So fun from my point of view. I like that kind of stuff. Yeah. So if we hit the next slide, I think it's going to say, is that enough? And the answer is it's a good start, but it's just the beginning. And the reason it's just the beginning is because you get all these wonderful benefits when you incorporate. The Business Corporation Act in Alberta and the one in Canada give these tremendous benefits to business owners. The issue is they also impose on business owners fairly rigorous obligations to maintain things. Okay, so if we hit that slide. Strict compliance with the Business Corporation Act, or what I often refer to as the BCA. So this is an interesting quote from Supreme Court of Canada, where they say those who have chosen the benefits of incorporation must bear the corresponding burdens. And that's kind of a summation of how courts treat non-compliance. So once you incorporate, there's certain regulatory things you have to do. And if you don't, nobody will give you the benefit of the doubt. Okay. So, and we'll get into what that means. But to say, and so one easy way to get around that is to hire a lawyer to manage your corporation. And it doesn't cost a lot of money. Most firms will charge, maybe $200 to $600, somewhere in that range, to manage your corporate minute book to make sure it's all in order. And if you don't, and you say to the court, well, I was doing this on my own and I didn't know better. I got a great quote from Master Funduck. He's an Alberta master. He had some great quotes, great beauties, but he said this in one case: if the defendant was to himself remove his inflamed appendicle, he can do so, but he will botch the job. If he wants to drill and fill his aching tooth, he can do so, but he will botch the job. If he wants to act for himself in this lawsuit, he can do so, but he will botch the job. And he has. So he was kind of a colorful master. And I like that quote because, and a lot of lawyers do, because there's a lot of pitfalls in court in general. But just to give you an idea that the courts won't give you that, oh, woe is me, I'm just a lowly business owner, help me out here, court. The courts look at it very harshly. So it's important to make sure that's ongoing. So if we just flip to the next one. So here are some of the ongoing obligations after you've incorporated. You have to have a registered office, and that's a big one. So a lot of people will say to me, hey, Greg, I want to incorporate. I'm trying to save some money, so I don't want to give you that $500 a year to handle my minute book. I'm just going to do this out of my home. And I always read them the Riot Act, because to me, the $500 or whatever it is that you spend is the best $500 that you'll spend as a business owner. Your registered office is where all paperwork can be sent to. So if you're getting sued, for example, the Business Corporation Act and the rules of court say that a company or a corporation is served when the document has been delivered there. So if you use your house, so Widget Co. and Tyler goes, I'll do it. I'm going to keep it at my house. And Tyler, living on an acreage, may not, who knows what's going to happen. They come, they post it to the door. It doesn't say that it has to be delivered to a human being. It says it has to be delivered to the registered office. So they post it to the door. That is it. It's been served. Now, you might have cameras, so you might see what's going on in today's day and age, but a neighborhood kid comes by, grabs it, goes, what's this? Leaves it, and it blows off in the wind. The tape doesn't hold, and it blows off in the wind. Family member grabs it, doesn't know what it is, throws it in the garbage. You've been served. The corporation's been served.
Pretty sure they take a picture of that on your door.
That's right. Well, they'll swear an affidavit to it saying, I did this, independent party saying, this is what I've done. So again, the courts don't treat the woe is me as an issue. And in fact, if we flip the slide, there's a good quote here from Alberta courts. The defendant is required by law to have a registered office, and it did have one. If that registered office moved without an immediate update with the registrar of companies, the fault is not the plaintiff's. So the person trying to sue them doesn't have to guess. It's easy. They do a corporate search, they see the address, they go there, it's done. That happened. There's ways to unwind it because mistakes can happen, but it's usually very costly, and it creates a lot of problem for the corporation. So the other part of maintenance of your corporation, not just a registered office, but your records office. So the registry system for corporations is part public, part private. So that means as a private organization, you have to keep public documents in order. So the records have to be kept in order. And so some of these records are public, at least to certain people. They're quasi-public. So like creditors, for example, have a right to see certain things in the minute book. And so if your records address is your house, during regular business hours, in theory, a creditor can go to your house and say, I want to see the corporate minute book. Now, I'm not sure if that's actually ever happened in my experience, but the possibility is real. What has happened in real life is creditors have come to my office and said, I want to see that minute book. So I set them up in a signing room and I show them what they're allowed to see, and I stand over top of them. And if I allow them to make photocopies, if it's appropriate. So again, you have that layer of protection to have a lawyer involved, which I wholeheartedly endorse and enjoy doing for people. It's a big part of, it gives me joy in my career.
Dealing with creditors?
Yeah. Well, dealing with helping people protect from creditors, right? The big bullies. I don't like the bullies. So as kind of a parting shot out there before questions, I'd just like to say there's also issues about management. How do we deal with decision making? Like if in our Widget Co situation, Tyler is a shareholder and he's also a director, let's say, and Dave's a shareholder and a director, and Greg's a shareholder and a director. And we say, okay, hey boys, it's been 5 years. Widget Company's making lots of money. Time to cash out. I want out. And Tyler and Dave are thinking, no, I want this to last another 20 years. We want this to be generational. Well, how do we deal with the resolution? And the Business Corporation Act has some remedies for minority shareholders called oppression remedies, but they're hard to get to, and they're hard. You have to get the court involved. So oftentimes people say ahead of time, hey, let's set up a guideline as to what we're going to do if and when we disagree with each other. And often that's called a unanimous shareholders agreement. And that will replace the director's authority. It replaces the shareholders' majorities will is kind of a constitution of the corporation. So those are some things to consider as well.
Great. So we're going to open up for questions.
Yeah.
Yeah. Okay. So we'll let anybody kind of put things into the chat there and we can ask away. We do have some of our own questions. I think we'll get Tyler here fired up with a couple of these.
Well, just kind of rolling back to the very beginning, Greg, you were talking about sole proprietorships, and we see a lot of sole proprietorships, people operating that way. At what point do they want to become incorporated? By my understanding and what you've talked about already today is you should incorporate right out of the gate pretty much. It's a layer of protection because otherwise you're exposing yourself to potential litigation. It's just a layer of protection. You're creating a separate person, if you want to call that corporation a person, to take the brunt or hit. So would that be something you'd suggest? Like sole proprietorship shouldn't even really exist. It's just a difficult way of operating. Yeah,
I mean, that's a very good point. And it's a point that that business people have to make. The blowback I get from that exact comment, because that's exactly what I recommend to people, is as soon as you're doing business, incorporate, because it's a layer of protection that you can't do after the fact. Once you start doing business as a sole proprietor, during that window of time, you're on the hook. So 2 years go by and someone could still sue you. So yeah, I always recommend as soon as you're doing business, incorporate, but that has to be tempered with, is it financially worth it? So if you're making 10, 15 grand a year during your side business, do you need to incorporate? I mean, you're paying $3,000 to your accountant, a couple grand to your lawyer. Does it make sense financially? And the answer that every person has to answer that on their own. But certainly from my point of view, if you're making enough to cover the costs of it, do it.
Right.
Just because too much is at stake.
Right.
From my point of view.
Yeah, all your personal assets are at stake.
Yeah.
And then you got into a more complex diagram of how corporations, this corporate structure can be pretty complicated. But it would look like to me that you don't really have to introduce holding companies until you're accumulating assets inside of your corporation, whether those assets are equipment or whether they're profit that you're retaining inside of the corp. Would that be what your suggestion is? If you're spending everything in the corp, and there's really nothing left in it, like in your example, is just an old laptop and a fax machine in there. I don't know who uses faxes anymore, Greg, but it could be in there.
Love my fax.
But really beyond that, it's you're wanting to shift and start introducing a holding company and start complicating that structure once you're retaining assets in the corp. Is that right? Or?
Yeah. Well, that's at a minimum when you would do it. Like so again, like I would tell you to set up the whole web right away, because then there's less risk. So if you do it once you have assets, the risk is somebody treats that as a fraudulent preference. So because you're taking assets held by the operating company and you're shifting them into a holding company. So what you can do it, and accountants are good ways to do it on a tax-friendly basis, and we can do that. Costs a little bit more later on, but you have the money to pay for it. Whereas when you're first incorporating to set up that big web, it's cheaper to do it, but it still costs money and you don't have the money yet.
Right.
So it is kind of a catch-22 for people. But I do, like, from a legal point of view, you set it up right away. If you think that at one point in time in your career, in the business's career, that it's going to get to that level, set it up now from my point of view.
So bare minimum, have this initial structure of shareholder owning the holdco owning the operating company. At bare minimum.
Yeah.
Well, we run into this quite often. I mean, especially in the wealth management side, the way a business progresses over time, the accountant and the lawyer, typically they're first trusted advisors. They don't have a lot. They're just, starting, and they build up and they build up and they build up. And then they start looking at, maybe we need to move some money into other holdings other than just our corporation. So they either invest through the corporation or they're taking money out personally and they want to invest that. And by the time we get there, sometimes, that structure was never put in place. You have one shareholder, you're trying to get a spouse on, or even an adult child. I mean, you start running into a lot of issues, especially when it comes to drawing money out. We have lots of holdcos with millions of dollars of assets in them invested, and now you're drawing them out, but you only have one shareholder on it. So one spouse is receiving all the income and being taxed at quite a high rate. Whereas if they had structured it differently back in the day, you're now taking that income every year and splitting it more than one way.
Yeah. There's certainly tax benefits. I mean, I'm not going to speak to those benefits because I don't know enough about it, but absolutely I'm just talking about strict liability. Like when you're just from a pure liability perspective, yes, set up holdco, set up operating company, set it up in that order. But again, I recognize that people who are starting business often aren't saying, oh yeah, I'm happy to spend $5,000 to get it all started up. Right? Like they're looking to say, no, I want to do it for the bare minimum.
Absolutely. And
And I get that. It's just, and I also get the idea that it will cost more later for them to set it up like that, and they're recognizing, but I'll have money later. So that's okay too.
you started touching on very briefly unanimous shareholders agreements. How do you use them? I've got some notes here in front of me, but people may hear of shotgun clauses and right of first refusal. Describe those, I guess, to us. What does that mean? So somebody who's incorporated and has a partner or shareholders, what would a shotgun clause be in that agreement? Yeah,
good point. Thanks, Tyler. So the USA overrides all your other subject to what the Business Corporation Act declares, but it basically overrides your relationship. And you say, look, if we can't agree on stuff, we'll turn to this USA or unanimous shareholders agreement, and we'll look at what we agreed to way back when we started up on this business. And so so Tyler and I don't like Dave and our widget company.
What?
We can say, hey, we're going to use a shotgun clause. Okay. And so what a shotgun clause says is we're going to buy your shares at this dollar amount per share. We're going to give you $50 a share, Dave. And if you don't like that, you can buy us out at $50 a share. And that's it. It's A or B. And so that's how the shotgun clause works. But there's other clauses that you can put in there that are also very beneficial or can be. So Tyler finds somebody who wants to buy his shares in Widgetco, and they're going to give him a lot of money. They're going to give him $1 zillion.
Take it.
And Dave and I go, yeah, that's awesome, man. When do we get our check? Yeah. And Tyler goes, yeah, sorry. They just want my shares, not your guys's. Now that would be a very unusual, weird spot, but in theory that could happen. And so what all the parties at the beginning of the relationship say is, why don't we have a tag along provision? And a tag along provision is if somebody's going to buy one of our shares, the other guys get to join in. So in the case of Tyler selling his shares, we would have the right to say, well, no, you can't sell your shares unless we get to sell our shares first. Okay. So that would be a tag along. And then a similar concept would be a drag along. So Tyler finds this $1 million or $1 zillion purchaser, and Dave and I are holdouts. And we're like, no, we think we can squeeze them for more. And we're not going to sign off. Meanwhile, the purchaser has told you, I'm not buying your shares unless these guys sell theirs too. So you can turn it on us and say, look, you guys can buy my shares at $1 zillion, or you have to sell your shares to these guys for $1 zillion. So that's the drag along. Again, when you're talking about big money, usually everybody's so happy that they get, they're happy. It's going to happen just fine.
Yeah.
But this is a case where this is real life situation where you might have a holdout saying, A, I think we can squeeze them for more, or B, no, I want this to be an intergenerational thing. I want my kids to have this too. Right. And it's like, well, remember we agreed that if the price is right, you either have to buy me out or you have to come with us.
Right.
Okay. So then the other thing would be a right of first refusal that you mentioned.
Right.
And that's just, it's a similar type thing is where someone said, hey, I want to buy your shares. And Dave and I would first have the right to say, well, before you sell it to Joe Smith, we want to buy him at that price. Right. And then we'd be allowed to do that.
And I think the USA also deals with death or impairment. So if Dave, in your example, can't work because he's either disabled or dead, what happens then? Or do we immediately have to buy his shares, or does he have to sell them? Can he keep them? Is that written into that agreement as well?
Yeah, right. Well, that again, that can be. That's exactly right. So oftentimes the three of us are good friends. We want to do business together. We know each other from a business relationship, and we say, yeah, this is going to work. But I don't want to pick on anybody, but let's say one of us is married to somebody that the others don't like, or even if we like them, we just don't want to do business with each other's spouses. It really has nothing to do with like or not. Are we prepared? Are you guys prepared in this relationship to deal with my wife or my executor or my attorney because I can't make decisions on my own? Mm-hmm. Are you guys prepared to deal with that person? And the answer is generally, you know what? No, if something happens, we'll buy you out. Mm-hmm. Okay. And that's exactly it. So you have a kind of a death or impairment clause that would say, if one of us dies or if one of us becomes impaired, you get to buy the other one out.
Perfect.
And then you get into that idea of impairment and what does impairment mean? Because sometimes impairment can be like, I got hit in the head and I can't think straight anymore. Well, that's one type of impairment. The other impairment is I get hooked on alcohol or crack or meth, and you guys are like, Greg, this ain't working. We want you gone. Yeah. And so you can kind of split the impairment and say, if it's, I don't want to say a natural, but if it's a critical illness type impairment, you get bought out. But if it's because of alcohol or something you did criminally, we're going to buy you out at a cut rate because you put us in a bad spot. And so now we have to buy you out. We have to find all these funds. And so we're going to pay you a little bit less.
And so that's written right into the agreement that you get a reduced cost on the share.
Exactly.
Okay. Yep. Like your punishment. You get.
Yeah, it's a punishment. But I mean, another way to look at it is the other guys are left holding the bag.
True.
So it's not really a punishment so much as helping the other guys through what you've put on them.
Mhm.
So
Finding money is always hard.
finding money is hard. Yeah,
Yeah.
exactly. Which is actually another thing that you can build into it is insurance. So, and you guys are excellent at that, where you can say, okay, look, in death, we're going to have the corporation get insurance, and how that insurance all works. I know you guys know all that, and you guys will talk about that, but yeah, so that then that doesn't put the burden on the corporation. It actually is set up so that, yeah, we're good. We're good. We can buy you out. Your estate can deal with itself. Lots of money to make that happen.
Yeah, finding a USA is a struggle for most, and the insurance generally is the easiest way to go about it. That's for sure.
We got a few questions here.
Oh, do we?
So
Okay,
yeah,
well, let's jump into it.
kind of this is a question in regards to, protection, shareholders, directors, things like that. So shareholders are protected obviously through incorporation. How about directors? If you have a director on your holdco, your opco, your lease co, are their personal assets protected in the same way? And what about negligence in that case?
Yeah, well, those are all good points. So a director takes on some liability, mainly to do with legislated things. Like, so let's say you have employees and they're not getting paid. Well, a director is personally on the hook to make sure employees get paid, as an example. I'm not sure how many taxes are like that, but GST, if the directors don't pay or if the corporation doesn't pay GST, the directors are personally on the hook for that. There's certain organization, I think WCB can claim against directors personally. So there are certain situations where directors on the hook personally. Shareholders are on the hook personally if they receive dividends that the corporation can't pay. So if the corporation can't afford to pay a dividend and they receive that dividend, a shareholder's on the hook personally to the extent of the dividend. Now that's all subject to fraud. If shareholders are partaking in fraud, or if there's sinister elements at play, there's ways to what they call pierce the corporate veil. I don't know if you guys have ever heard this, but the corporation is seen,
like a movie.
It does. It's seen to have a veil on, and you're dealing with a corporation, but who's behind the veil? Like who's really there? Yeah. And it's the shareholders who are the human beings behind it. And so they call it the corporate veil. And in order to pierce the corporate veil, to go after the actual shareholders, there's a whole bodies of case law on how to do that. So what I talk about today is really kind of in a general sense, in a general type litigation, what will protect you. But there are ways to pierce the corporate veil, and fraud is one of them. Negligence is not really like if a director acts negligently, could he be sued? Yeah, I suppose a director could be sued for negligence, but it would be independent of the actual claim against the corporation. So that'd be kind of one of those where it'd be a case by case. If somebody is a director out there and they're watching this and they're like, oh my goodness, I'm in big trouble, you'd probably want to talk to a lawyer.
Awesome. Another one here. It looks like this individual, their real estate company is owned personally and not by their holdco. Is that a problem?
What is owned personally?
My realco, so real estate corp, is owned by them personally. So they're the shareholder of the real estate company, and it doesn't sound like they have a holdco in the mix.
Yeah.
Is that a problem?
Well, I like to create the web of companies. So come talk to me at the office. We'll set you up. We'll get you 10 or 12 companies. No,
one for each property.
It kind of depends. Every case is different. So if your real estate company is starting to build up assets, you might want to consider creating a holdco to have it, to have a mechanism to have the funds and the assets flow through it. So that'd be, you'd want to talk to your accountant. You'd want to talk to your lawyer about the feasibility of that happening.
Okay. And this is good because I had a question I wrote down that ties into this because we run into it with a lot of clients, and this is the flow of assets between holdco and opco, holdco and realco, holdco and leaseco, any of these things. Often when we're dealing with a client, they're sitting on, $1 million in their opco, and we're like, okay, get it out of there for, liability purposes, get it into your holdco. We'll set it up in some investments. And part of the problem for them is, well, I might need that money. And so it's like, well, you're better off with it up to your opco first, your holdco first, and then loan it back to your operating company. So in that, from what I can tell, is there supposed to be a properly written document that you're loaning money back to your operating company? Because I think people do it all the time.
Yeah.
They don't write them up.
That's right.
Now, are they supposed to have this signed off by a lawyer typically, or can you write your own promissory note to your own corporations?
Yeah. I mean, it's all about evidence at that stage.
Yeah.
So you're worried from a legal point of view, because there's going to be tax considerations for all that happening.
Right.
Okay. But from a legal point of view, you run into problems if you're seen to be taking money out of your operating company and stuffing it into the holding company, and to the detriment of a creditor. Then a creditor says, well, what's going on here? And you say, well, this was a reasonable business move that I was doing. This is just for business purposes. This is what we always do. Well, then you have to prove it, right? Because you have to say, well, let me see the loan. Well, if you have a hand-drawn napkin saying I owe the company, or holdco's opco, whatever, or opco's holdco, did you just draft that before our meeting today? And well, maybe. And so you get into trouble with that kind of thing. And so, or you can get into trouble with that. So the more you document real time, the better it is.
Yeah.
But that's not to say you can't say, I'm busy, I'm a businessman and life is busy, and this is what happened. And 6 months go by and you come to your lawyer and you say, oh, hey, Greg, 6 months ago, this is what I did. I need that papered. Well, we can document it. That's fine. We can always document it after the fact, but it's best to do it as close to the nexus as possible for evidence.
I mean, if something happened to that individual 2 months later, they're going to be, upset that they took 6 months to get it papered.
That's
if you papered it the day it happened, and something does happen litigation wise, I mean, 6 months, 8 months later, well, that could be construed as you were shuffling assets. But if you're automatically just putting something on paper every time you move money back from a holdco to your operating company, real estate company, whatever it is, and you've got those loans all on paper, well, I think you're pretty protected there. And if you don't, you're not protected at all. Like you'll end up potentially money from your holdco back to your opco, and something happens to your opco, that money's gone.
Yeah. And and your security for it, I mean, this is a good point too. So when your holdco lends money to the opco, if the opco still has some assets, it can pledge those assets back to the holdco in exchange for that loan.
See, now that's really good. So that's another layer. I mean, if you're getting into, beyond just moving pure cash and not having, if you had an opco with, like you said before, a notebook and a fax machine in your company, obviously, but you're not worried about pledging your fax machine
That's
back.
right. I want that fax.
I want that $10 loan, maybe you would, but yeah. Okay, so we have another question here. So in your experience, to what extent are professionals, where there is a governing licensing professional body that sets out how corporations can be set up, are professionals limited in their ability to set up this web? So obviously, there's all these, almost like comparing software. Oh, okay, you're a dentist in Ontario, there's a dot there. So what's your take on this, all these different professionals on the web?
So everything I just said today is not applicable not to most professional corporations. So professional corporations are called professional corporations. They're not called Inc. They're not called LTD. They're not called pick your abbreviation, right? So professional corporations under their governing legislation are dependent. So I'll speak to lawyers because I know this for me, but as a shareholder, I have the same liability as my corporation. So if my all voting shareholders in my professional corporation have the same liability as the corporate, as my professional corporation. So to set up a web for liability reasons makes no sense. Does it make sense from a tax point of view? Sometimes, sure. Maybe it does. I do get tax plans for dentists and for doctors and for chiropractors who, for tax reasons, they want to set it up that way. But really from a liability protection, it does you no good because you're still on the hook. So not only do my voting shareholders carry that liability, but only in my case, can I be a voting shareholder in my company, in my corporation. So you have to be a member of the professional body to have voting shares in that. So my spouse, my wife, she can have non-voting shares in my company and she has no liability, but she can't have voting shares.
Okay.
So, and that would apply to most professional corporations.
So and let's just kind of stick on professional corporations because that's quite a lot of the corporations that are out there. It becomes a harder planning, not just, as you said, for liability, but planning around, because, in the wealth management business, we're always looking for the next step, and the better prepared that corporation is for, say, retirement of the shareholders, the better the tax situation is going to be and their net worth. So, as you say, there's no reason to do it for liability, but having your spouse on your corporation, especially a professional corporation, is probably not a bad thing, because at some point you do retire. What happens to your professional corp?
Okay.
It's no longer a professional corp. It becomes a holding corporation. If your spouse isn't on that before the assets have accumulated there, it's very difficult to add them on without them, writing you a check for half the value of your professional corp.
Yep.
So it might not make a difference for liability purposes, for voting purposes, for any of those things, but it certainly would make a difference come time to convert your professional corp to a hold corp. And we're dealing with a situation like that right now, and off to the accountants and the lawyers you go to look at freezes,
yep,
and all sorts of things that are very costly. To fix what wasn't done in the start,
exactly,
costs a lot of money down the road. And maybe you don't want to tell everybody that, Greg. Your business will suffer. Yeah.
So
pay now or pay later.
Yeah. Well, that's just it. And again, you get into the situation where pay now, get it set up, but I don't have the money now. So pay later costs more, but I have the money to pay for it. So it is one of those things. I know for most people I know who have spouses, it's kind of a no-brainer, but there's other complicating factors in it. I know my accountant has told me that if you own shares in the same corporation, your two corporations can be linked for tax purposes. So do I know enough about it? No, but I know that I talk to my accountant and I say, okay, what kind of shares should we have? And then they kind of walk me through that. And that's the advice I'd give to clients too.
Yeah.
I say, okay, I've heard that there's some benefits in getting your spouses involved early. Talk to your accountant. If that's a good idea, let's do it. As opposed to when it's for liability protection, what I talk to people about is let's do it. Let's set up the spouse. Let's do this in this way.
Yeah. To me, if you're going to have somebody with a newer corporation setting up their web, I know, like you said, it's costly and maybe people don't have the money to do it at that time. But if they at least were business planning, there's a cost to starting a business. And if you factor this cost in, which I think is important, you can get things set up quite well. But one of the things Tyler and I always promote, and what we're trying to do with the professionals we work with, is to get the right people in the room at the same time. Because you're looking at it and they're like, yes, let's get this set up, from the start, the web, let's get the liability protection in place. And the account would be, okay, well, great, let's do that too. But let's make sure we get the right shareholder structure, the right shareholders on each of the corporations. And we'd be like, okay, let's make sure it's set up so that we can be shuffling money to, prepare for investments inside of the holdco, or the use of some insurance to protect the holdco, all of these things. So that doesn't happen till later on. But even if you're adding these things after and it costs a bit more money, it's really, I think it's important to look at your team and get the answers from the group of them, because one person might be giving advice solely based on the question you're asking, because it's not because you aren't asking the right questions, you just maybe didn't ask a specific question for something that they're not, registered to discuss or don't know the answer to. So it's kind of it's a big web. Yeah.
I think that's super important. I know, exactly like your point. When someone says to me, how many incorporations should I do? I just get my pad of paper out and I start drawing circles all over the place. But then I do recognize, okay, well, you want to plan for your wealth, like your wealth distribution. How is that going to happen later on? Who's your investment guys? Your accounting team, they need to be aware of all this, because absolutely all those parties do need to communicate. For my part, I try to be very careful, because I don't want to mislead people in thinking that, I know how to plan your taxes and I know how to plan your insurance and your finance, your investments, right? So it is important for people to not just get that one piece of advice. Absolutely.
Yeah. And I think of the corporations that we deal with and the shareholders. Now, fortunately, I think for the most part, we haven't had anybody have a really big liability issue. But, we do get to the part where we're sitting down with someone who's new and you look at the structure and go, oh boy. And, with the sheer amount of money in there and you're like this, you built a successful business and you siphoned off the profits. You didn't take them all out and spend them haphazardly. You have this pot sitting here now, but it's all in one person's name. It's like the sheer cost of taxation on that mistake.
Incredible. Yeah.
For all of your effort to build it up, you're going to give away a large chunk to make this right, or you're going to pay a lot of professionals to do a lot of shuffling.
And that absolutely happens. I mean, there is so many examples in my mind where people have built up empires, big empires, all under their hard work and know-how, and they do it. But at the very beginning, they didn't get that advice. And now they're set. Okay, well, I want to sell, or they pass away, or whatever. And it leaves everybody else in just kind of a scramble, or pay a ton of taxes.
Well, I mean, it's something we find in, it's like RSPs and RIFs, you know what you were doing when you're putting the money in, but then one day you're forced to start taking out and pay tax, and we get a lot of people going, well, if I would have known I was going to pay this much tax, this doesn't even make sense. Yeah. They don't remember getting the refunds, even though they did when they were doing it. Right. When it comes time to taking this RIF out and the government's forcing them to take out 60, 70 grand and their OAS is being clawed back and all that. They're like, well, this was bogus. RSP suck. Well, you did kind of get all the refunds for all the years. People forget what they've been told. Yeah, sometimes back in the day, and especially when you're incorporating, you're like all out, over your business. You can't wait to grow this thing. You can't. And sometimes pieces of advice are, well, it's not right time for me. I'll get on it. And then you got all this wealth.
Yeah, that's right. So that's right. Yeah, that's exactly it.
See, do we have another question here? Oh, we just got someone. They got to run, so they enjoyed the chat with Greg. So what else do we have question-wise here?
I think we're good on questions, and we've pretty much come to our hour allotment. So, wanting to be sensitive to everybody's time who joined us today, and so I just want to take a moment to thank Greg for being here. Greg, thanks for sharing your thoughts with us and your knowledge with us. It was great, and we appreciate you coming down to join us on Smokin Bulls.
Thank you for having me.
That's great.
Much appreciated.
That's awesome.
So, thanks for watching this episode of Smokin Bulls. If you want to learn more about us, head over to smokinbulls.com or follow us on social media.